All right, folks, just going to go ahead and get started with a little introduction here. So good afternoon. Thank you for joining us today. My name is Jay and I'm the office manager here at Standpoint. So I want to begin today by reminding folks that this webinar is being recorded. When the recording link is available, it'll be sent out on our legal advocates listserv and also added to our YouTube channel and website. My role today is going to help facilitate the webinar. If you have any questions during the presentation, please type your question in the Zoom chat or Q&A tab, and I'll make sure our presenters are able to address your question or comment. Most of you probably are a little familiar with our organization already, but for those who are listening to this later, Standpoint serves the entire state of Minnesota. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We do this through answering calls to our action line, and our action line is answered Monday through Friday from 9 a.m. to 4 p.m. It's through that action line that our attorneys provide legal advice and our advocates connect callers with resources, safety plan, listen, and help identify possible options and next steps. We also provide assistance to systems professionals who work with survivors. Our staff facilitates training such as our annual new laws throughout the state of Minnesota and monthly webinars for advocates such as this one and other trainings by request. So for today's presentation, I've just shared in the chat box a Dropbox link to the PowerPoint slides so you're able to follow along. Now without that little business out of the way, I'm going to pass it off to our presenters today.
All right, thanks, Jay. Hey everyone, I'm Maddie Nelson and I'm one of Standpoint's legal advocates. And I'll get us started off with a quick look at our agenda here. Today we're going to be attempting to cover a lot of things. We're going to do a general overview of the work of community advocates and victim witness advocates. We'll talk about relationship building, confidentiality, boundaries, advocacy versus advice. We're also going to discuss court preparation, working with special populations, and online resources. And as always, if you have questions during the presentation, just type them in the chat. We'll do our best to answer them as we go along here. And next slide. Okay, so to begin, let's look at an overview of all of the things a community legal advocate does. As we know, we wear many hats, and when you're just starting out, I think that the breadth of this work can feel very intimidating, especially because a lot of this work is learned simply through observation and networking. I know for me, it took a long time to feel like I really knew what I was doing in all the areas listed on this slide. And then there's the fact that the civil and criminal justice system is just constantly changing, as are the individuals who work within it. So it's very challenging work, but do remember that Standpoint has entire trainings, sometimes multiple, on pretty much every area listed on this slide. And you can find those in the archives of our YouTube page. So one of the most important areas we can focus on getting skilled at early on is assistance with writing OFPs and HROs. And if you're new to this work, it might seem like a general understanding is enough to be helpful. And while that's true to an extent, it is important to realize that there is potential to do harm if you don't have a good understanding of the statutes and the rights of the parties. Often victim survivors will come to us wanting to file orders that they don't necessarily qualify for, or they don't have a really strong case for. And as advocates, it is our role to help them assess whether or not they qualify and to be honest about it if they don't, so that they're not making moves that could get them in trouble with their abusers while not achieving the protection they're seeking. Sometimes there are unintended negative consequences from the type of relief someone's requesting as well. One example, something that we see a lot, our petitioner is unnecessarily asking for custody of their children through an OFP when they already have sole custody. This is most common, of course, with unwed mothers. I've seen advocates watch their clients do this and not inform them that it's going to trigger a hearing, which could then result in the whole order being up for cross-examination. And what's worse is that it gives the respondent a legal pathway for parenting time, which can be requested in an OFP, and which is the opposite of what the petitioner was hoping to accomplish. So when it comes to children on orders, whether they qualify as protected parties, whether custody needs to be addressed, it can just get really complicated and there is potential to open a whole can of worms. So it's really important to remember that when victim survivors come to us for assistance, they're usually forgoing their own research into how to fill out these forms. So at the very least, we need to be making them aware of what they'd find in the instructional packet. And then beyond that, there are many ways to strategize around writing a narrative, requesting specific types of relief, As I said, Standpoint has multiple trainings on this. In fact, Raina just did another one a couple months ago that you'll find on YouTube. So let's see, along with writing these is of course helping them prepare for court, supporting them at those hearings. I won't go into depth about that because Raelene is going to touch on it later. Another really important aspect of this work is helping the people we serve navigate the criminal justice system. So this often starts with helping them determine when and how to report abuse to the police. Sometimes it's possible to actually be present when they make those reports. So if they come into your office after being assaulted, maybe instead of sending them elsewhere to call 911, you can call for them and have an officer come right to you. And I know that's not possible usually in the shelter setting due to confidentiality, but if you do have the space, just being there while they do that can be a huge comfort. And you have to remember never to coach them around what to say or be reporting things for them during that interview because that can complicate the prosecution. But you can be educating them on criminal statutes, what it takes for law enforcement to establish probable cause, so they know whether or not what's happening to them is a chargeable offense, or so they can make sure to share all the pertinent information with the officer. Letting them know what to expect after their abuser has been charged, so considerations on DANCOs, supervised release, bail, especially who the contact person is at the prosecutor's office. Those offices usually have victim witness coordinators who act as a liaison between the victim and the prosecutors. And I'll go into that more later, but that person is able to provide a lot of information and support to the victim while charges are still pending. And it is true that this person, the victim witness liaison, might have a huge caseload and may be limited in how much attention they're able to pay to the victim. So in these situations, our clients might need a lot of handholding throughout the prosecution from you. Maybe they'd like you to attend a criminal hearing and report what happened to them. Maybe they want you to translate information from the prosecutor into language they can understand. Or help them communicate their wishes to that office, or they'd like help writing a victim impact statement. As we know, the criminal court process, it's extremely drawn out. It can be confusing, it can be re-victimizing, and unfortunately, it rarely feels like adequate justice for the victim. So supporting them through this as much as we can, it can really make the difference between a victim choosing to turn to that system again or not, if they ever need it again. I don't think I need to say much about resource referral other than the importance of giving a warm handoff whenever possible. And in case you're not familiar with that term, what that means is that you personally connect your client to the resource. So you make the call with them. And if they'd like, you introduce them, provide background information to the resource for them. Not only is this better for the client, because you might have a better ability to articulate their situation, but it grows and strengthens your network of system professionals and community services as well. And unfortunately, we hear from victim survivors a lot who feel like they've just been calling in circles. So doing warm handoffs prevents them from feeling like they're just being passed around by different resources. Throughout all of this, all of these things that we provide, there are opportunities to safety plan, educate people that we serve in the dynamics of domestic abuse. I think sometimes we think of safety planning as a one and done, especially if your office has forms on it, but it's something you're probably going to be doing every time you talk to your client to one degree or another. I also highly suggest having power and control wheels on display and copies in your office. These can be really helpful for victim survivors to identify and validate the abuse they've been experiencing. Let's see. Elli's going to go into confidentiality in a bit. So the last one here we have is navigation of the civil court process around custody and divorce. And this is an area that fundamentally intersects, but can feel sort of beyond our capabilities as advocates, I know. And while we certainly have to be careful not to provide legal advice, we can be pointing our clients in the direction of the forms. And we can have familiarity with how the divorce and custody process can shake out in different ways and prepare them for that. And I actually think that one of the most helpful things to provide in this area is a realistic estimation of their likelihood of finding free legal representation. We can and should be referring people to attorneys, but simply telling someone to call legal aid when we know they probably don't qualify or that the wait list is really long, it can be giving them false hope and an unrealistic expectation, and that really isn't helpful. So I usually prepare people for the possibility that they won't get free representation. So, that attorney in the courtroom with them, negotiating for them, but that instead they may have a better chance of getting ongoing legal consultation. So legal advice on their paperwork and the arguments they plan to present. There's a wider array of legal services that provide consultation than provide that full representation. And if they know to expect that, they can better prepare to maximize their time when they do get an attorney on the phone. And, one way legal advocates can be helpful around prepping for that consultation is to assist them in having their questions and timelines organized ahead of time so that they're communicating effectively. We can prepare them to have their expectations about the court process in a reasonable place. We can prepare them for uncertainty throughout that process. I think of it as sort of helping attorneys help them, because when we fill in that gap, it gives them more time to devote to providing important legal advice. Okay, you can change slides. All right, so I'm sure most of you who've been doing this work for a while have heard this many times, but relationships are the cornerstone of this work. And the very best way to initiate them is to ask your questions. So when you're learning to do this work, you should be on the phone seeking information a lot. This isn't just about getting those questions answered, it's how you learn who the players are and who your resources are. If when you do this, you're acting professionally, respectfully, you're giving positive feedback, empathizing with others' perspectives, you're going to start building partnerships with these people. And a lot of the individuals who work within the civil and criminal justice system just aren't super comfortable working with victims. So if you're easy to work with, they're going to want you at the table, and that's where you're going to be able to advocate from. And this can be extremely challenging because oftentimes the role of victim advocate can feel like an adversarial one. It's sort of the job to push the system to work better for victims. And when it's failing or system professionals don't seem to get it, it can be hard not to show anger and frustration. And there's definitely a place for argument and passion, but we always have to remember that at the end of the day, the players in the system are the players in the system, and they may have a lot of power over the outcomes for the people we serve. So is it more important to be right and prove our point, or to be effective collaborators and maintain relationships? Without those relationships, we can't get the information for our clients. We can't share and promote their perspectives. And that is, just essential to do our work well. Okay, next slide. So here we have the major entities that a legal advocate should be working to build relationships within. I would have to say that the police are one of the most important institutions to do this with. They just have so much power, and they don't always have the victim's trust, or they might be actually feared by the victim survivor. We also know that often what happens is that when a victim reports an assault, their brain is in an acute stress response, so they might not be communicating well in that moment. And then when they speak to their advocate later, they may be reporting many more details that they forgot to tell the officer, or they may have visible injuries that have since developed. If we can be that bridge to further communication or further evidence collection, that has a huge impact on criminal justice outcomes. But that usually involves having some type of relationship with the investigators. So someone to call and say, hey, the victim says that she didn't have bruises yesterday, but now they're visible. Or they're telling me they told you everything was fine at the door because they were afraid, but they're prepared to report now. Of course, always doing this with their permission. Also, if you're noticing concerning trends and problems with police responses, those relationships can be a good place to try to initiate solutions. Prosecutors, victim witness, also going to hopefully be one of your main partnerships in this work, especially if those individuals are stretched thin. There's an opportunity to help them help your clients by communicating their needs and arranging and attending meetings between the victim and the prosecutor's office. Court admin can be a big one for all the technical issues around paperwork, or even being able to facilitate communication with judges. If you have relationships with legal aid, they might be a great resource for your questions. I've even seen some legal aid organizations be willing to provide office hours at the victim agency as a way to expand their services to victims without necessarily increasing their caseloads. It also might be helpful for you to attend meetings between your client and their attorney in order to help them decode legal language, ask better questions. Relationships with other orgs can be useful in staying up to date on community resources. Social workers may be in the event that your client is dealing with a child protection matter related to domestic violence. Probation is a huge one. Often these people have huge caseloads as well, and they might not be having great communication with the victim, but they're willing to hear their input and concerns if you help them initiate and maintain that contact. And then lastly here, we have folks like judges, court security, family court professionals, defense attorneys. I'm sure I'm forgetting some, but even having a passingly friendly rapport with these folks can benefit your clients in unexpected ways sometimes. So, be sociable, friendly, curious, helpful. If these entities see you as approachable and helpful to them, your input is going to have more credibility. And next slide, please. Okay, so just to summarize and drive the point home one more time, make the call, ask the questions, set up the meeting. Always consider if there's benefit to seeking the information yourself rather than passing it on to your client to do so. Sometimes it's empowering for the client to do their own research, or you simply don't have time, which is legitimate. Or it might be that they're going to benefit from speaking directly to the resources. But as a practice, get in the habit of doing these things because they're going to grow your knowledge base. They're going to build relationships and they'll solidify you as a player in the civil and criminal justice system. And just a note here, I just want to stress the importance of confidentiality as you do these things. There are many ways to ask questions without referring to specific individuals. You can speak in hypotheticals, you can be calling with your client, or getting a release of information and their express permission before sharing details. And next slide. All right, so this is the last thing I'll cover before passing it along to Elli. In most city and county attorneys' offices, there is a victim witness liaison or advocate. They work only with victims whose abusers are being criminally charged by their office. And as I said prior, they are the bridge between the victim and the prosecutor. So they may provide similar services to community legal advocates, but there is a key difference, which is that a victim witness advocate is not a domestic abuse advocate as defined by statute. And they do not have a duty to keep victim statements or information confidential. That means that the info that the advocate hears is discoverable, which means that the prosecutor can hear the information that's shared, and then the defense attorney can have access to it as well. And this information can be used without the victim's consent. So that's something to keep in mind when you're advocating for your client with their office. The primary purpose of the victim witness liaison is to inform the victim of their rights within the criminal procedures and to explain what might be needed from them to prosecute the case. Many of these offices provide advocacy above and beyond this, including resource referral, safety planning, assistance with applying for reparations. They may even have victim assistance funds to pay for things like relocation and other safety measures. And often these individuals will attempt to do outreach to victims right after an arrest, and their office charges something, but that doesn't always happen. So do look to initiate that contact when appropriate. Okay, I think that is all that I have. So I'm going to pass it along to Elli.
Thanks, Ben. My name is Elli, and I am the Underserved Population Support Advocate at Standpoint. And I'm going to start with talking about confidentiality. Confidentiality is one of the most important aspects of advocacy, and it's something that we should always be keeping in mind. Like Maddie just said, victim witness advocates are not held to the same standard of confidentiality as community advocates. But domestic and sexual violence advocates do have confidentiality. And there are specific statutes that apply, and a lot of that is based on the funding sources that you receive funding from. And your organization probably has a policy, so it's important to make sure you're very familiar with that. Confidentiality is important because it allows clients to share things with us that they otherwise would not or could not. A lot of the things that clients talk to us about as advocates are things that they might feel embarrassed or ashamed of, things that are very private and personal, and things that could put their safety in jeopardy if other people knew them. So we need to always be protecting any personally identifying info of our clients. That means the obvious things, of course, like their name, their phone number, their date of birth, their address, but it also can mean other things as well. Essentially, you don't want to help anyone who is listening to you speak identify your client more easily. So you might be able to say, I have a client who lives in Ramsey County, but you don't want to be very specific about what neighborhood they live in, their age, where they work. Things like that are going to help someone who's listening possibly know who your client is. And you never know if someone who might overhear you knows that person or might know the abuser personally. And there's always a risk of safety, of putting your client's safety in danger. So you need to refuse to give information when pressed by other people. That can mean judges, law enforcement, other clients, family members of the client, other service providers. Law enforcement might be the people who are most often pressing you for information, and it can feel like you might need to tell them things because they have a sense of authority, but still refuse to disclose unless you have a release of information. Most of the time, the motivation of the person asking you for information is not malicious, but it could still be a safety risk for your client, and you still need to maintain that confidentiality. For example, your client's family member might call to shelter and ask you if that person is staying there because they want to drop off some of their property or get in touch with them. But it's still something that you need to refuse just for safety purposes. Law enforcement might be pressing you to tell you the victim's safety plan, but if you share that, it could put them in danger. And there is always a potential for harm. And as advocates, we hold a lot of power because we have personal information about our clients. When in doubt, do not disclose. You can always ask someone like a manager, supervisor, if you're not sure if you can disclose something, and you can call Standpoint for support with that as well. It's always good to keep the phrase in your back pocket of I can't confirm or deny. That is always useful and can help you avoid breaking your confidentiality. Having a third party present in conversations will also break your confidentiality. So try to have clients be in a private space with you or have them be the only person on the phone whenever possible, and let them know that the reason for that is confidentiality. If you are subpoenaed or your organization is subpoenaed, please reach out to Standpoint as well. Raina, our executive director, can help with that. She's an expert in confidentiality, and advocate data is protected, so she can help you walk through that process. Basically, you cannot disclose information unless you have a signed release of information or there's a court order that's compelling you. And with a release of information or an ROI, signing is always voluntary. Never pressure a client to sign an ROI, and avoid anyone else pressuring your client to sign as well. As an advocate, it's your responsibility to explain to your client what signing the ROI will mean for them. Releasing any information could give someone their exact location or can confirm that they're receiving services from you, and that could be dangerous for them. So you want to discuss the risks of sharing that information. And it's very important to be specific about what information you are releasing and how. So do you need access to the entire file or just the fact that this person is receiving your services? Be very specific and ask the person who is going to need that information what kind of information would be necessary. Once someone has information, you can't unshare it. You can end the release, but once someone has information, you can't control what they do with it. And that's something to keep in mind when you're sharing. If they want you to be able to discuss information in the future, then there needs to be a time-limited release. So let's say 3 months from now, they want you to be able to discuss information from their file with someone else. Make that specific on the ROI. And a written release is always going to be the best possible ROI, but a verbal release can be helpful in an urgent situation or a situation where you just can't get it in writing in time, if you get a verbal ROI, make sure you write down when and how consent was given and what specifically the release was. And we do have some webinars on confidentiality on our website and on our YouTube page. Confidentiality 101 and Can I Tell You This are both going to have more specific information about confidentiality and the specific statutes that apply. Next slide, please. And now I will talk about boundaries. Boundaries are almost as important, or maybe just as important, as confidentiality. In our work, it is important to build and maintain strong boundaries when you're working with clients. That can look like saying no to certain services or to certain client requests. It can mean that when you take breaks and time off, you don't work while you're off. It can mean hanging up when a caller is yelling at you and insulting you. And it can look very different for each situation. For example, advocates who work 9 to 5 might have the boundary that they won't answer the phone after 5 p.m., but on-call advocates can't set that same boundary. And so you'll have certain boundaries depending on your situation. It is a skill that can be learned and practiced, and it's a good skill to have in life as well as in advocacy. Some of the reasons for this are to prevent burnout. Our work is very empathetic, and it can be emotionally exhausting, and advocates can even face secondary trauma from our work. That can lead to burnout, which can seem like apathy, dread, or intense anxiety when thinking about your work, feeling a sense of hopelessness, resentment, guilt, or obsession with work, never being able to stop thinking about your work. And we want to avoid burnout because it's something that can take a very long time to recover from. So preventing burnout in the first place is going to be the best possible outcome. And boundaries are something that can help you in preventing burnout. We can also, as advocates, be good models for our clients with setting boundaries. You might have clients who don't have boundary setting skills. Maybe that was never modeled for them when they were young or in their families. And maybe people have told them that they're not allowed to set boundaries, or people have walked over their boundaries before. When you set boundaries with your clients, it benefits them because they can learn from you that they can also set boundaries and that people need to respect them. Your clients will be more empowered and self-reliant, and you can maintain professionalism and that professional rapport with your clients and maintain your capacity. The nature of our work also means that sometimes we get callers who are in crisis or who are very upset and angry, but that doesn't mean we need to put up with abusive treatment or people screaming at us or insulting us when we're on the phone or speaking with clients. And I encourage you to set boundaries with clients in those moments. Some ways you could do that are by saying, this is not a productive conversation. Let's talk later once we've both had a chance to calm down. Or, I cannot continue to be your advocate if you're going to speak to me that way. Remember that you are always a person before you're an advocate, and you don't deserve to be screamed at, threatened, or treated in an abusive way, just as your clients don't deserve that either. Having strong boundaries can also help ensure your longevity. Every person and every organization has capacity limits, and working beyond our capacity is not sustainable, and it means that clients are not receiving the best possible services from us, and that staff are stretched thin and even burnt out. Setting strong boundaries allows us to continue to work in a healthy way, which usually means we can stay in the work for longer and we'll have less turnover. We cannot do everything, and we shouldn't try. And setting boundaries helps us maintain our overall health. Like I said a little earlier, it is preventative self-care. A lot of times we talk about restorative self-care, which is also important. And we know that self-care should be social and physical, emotional, spiritual, mental. But a lot of times we're talking about the things after the fact. So calling a friend, receiving counseling or spiritual guidance, or those things that we always say, like taking a walk or taking a bubble bath. But preventative self-care is just as important. People in helping professions like advocacy often ignore our own needs until we are totally burnt out. And that's not something that we should continue to do. It's not a good pattern, and it doesn't serve us or our clients. Our work can be very emotional and traumatic even, so it's important to keep a good work-life balance. We cannot work 24/7 and be healthy and successful. We need to take breaks and ask for help and support when our workload becomes too much. Use your PTO and sick time if you have it. Be honest when you're feeling overwhelmed and you need a break, or you need to change your work expectations. We cannot be personally responsible for everything, and we shouldn't be feeling personally responsible for everything in our clients' lives. Everyone has a capacity limit, and that is okay. We want to empower our clients and avoid that savior complex. We are not saving our clients, we are supporting them. And there are some good webinars also on our YouTube and website, Self-Care for Advocates 101 and 201, and I really encourage you to take a look at those for some helpful techniques. Next slide, please. The last thing I will talk to you about today is legal advocacy versus legal advice. This is something that is not always clear-cut. It can be difficult and feel like you're treading the line in between the two. So as advocates, we can use our experience and information to give options and explain typical processes. We can give resources, define terms, share forms, and even help draft forms with clients. We can share statutes and explain what they say in common language, but we cannot apply them to the facts of our clients' cases. So we also cannot instruct clients on what they should or should not do. Only attorneys should be applying the facts of a client's case to the law. Advocates don't have the training or license to practice law, and that also means we can't take on that liability that lawyers are taking on. Even if you have a good idea based on your experience and your knowledge of what a client should do in a certain situation, it's not your role to advise them. Advocates are there to inform and support clients only, not advise. I always use the term expert in your own life. Clients are the experts in their own lives, so we want to give them the tools, resources, and options so that they can choose best for themselves and make informed choices. But sometimes they do need legal advice, and that's when you want to make a referral to an attorney. Whenever possible, refer to an attorney that you know or that you know understands the dynamics of violence. And if you have an attorney in your organization, maybe that attorney can provide a legal advice call, and you can always have your client give Standpoint a call as well. And now I'm going to pass on to Raelene to talk about prepping for court.
All right. Thank you so much, Elli. I just wanted to check in real quick and see if there were any questions that had come in or other things that people had. It doesn't look like it, but just wanted to make space for that. Know that you can always throw those in the chat box, and we'll get to those as we go. So first, so my name's Raelene. I'm the housing advocate here at Standpoint. I'm sorry, I failed to mention that. What we're going to talk about today a little bit is court prep, and what does court prep look like for advocates? So we have a really good understanding of what community advocacy does and the many hats that we wear in that role from Maddie. And we just learned from Elli a little bit about legal advice versus legal advocacy. So what does that look like? What does our role look like? So first we'll start a little bit with the Minnesota court system basics. This is super high level. This is not, Schoolhouse Rock version by any means. And we're also not going to touch on tribal or federal courts. You'll have to check out some of our YouTube videos to learn a little bit more there. But first, what type of courts does Minnesota have? So we have three main types of courts. We have our district court, which you see on the bottom left or the left there. Almost 1.3 million cases in the state court system begin at the district court level. The district courts are located in the courthouses in each of the state's 87 counties, and there are 296 judges serving. The district courts are then organized into 10 different judicial districts. In the middle there, we see, well, the doors at least, to the Minnesota Court of Appeals. And the Court of Appeals reviews district court decisions if one of the parties feels that the case was decided improperly and files an appeal. The 19 Court of Appeals judges sit in 3 judge panels to hear oral arguments in St. Paul and other cities across the state. They hear on average about 2,000 cases per year. And then we get to the Minnesota Supreme Court. And the state's highest court has 7 justices who hear appeals as a group from cases that were decided by the Minnesota Court of Appeals. And they also hear cases from the Workers' Compensation Court of Appeals and the Tax Court, which we are definitely not talking on today. The Supreme Court also automatically reviews all first-degree murder convictions and legislative election disputes. The Supreme Court hears about 700 cases per year, and they serve as the final guardian of the rights and protections provided in Minnesota's Constitution and interprets and applies the US Constitution. Fun fact, Raina recently argued a case before the Minnesota Supreme Court and won, protecting the privilege of sexual assault counselors, so we're pretty proud of that. And if you'd like more information, please feel free to reach out. Most of what we do as advocates is going to be in those district courts, so the courts that are in your county. So in the metro area, there are different divisions in each of those courts that help sort out different types of cases and help kind of with the administration side of things and making calendars easier and kind of organizing and grouping cases, such as housing court and family court. In rural areas, there may not be a need for those divisions, and there's just one courthouse to be going to. It's important that you get to know the court system that you are working in so that you feel comfortable and can help and prepare victims and survivors. Keep in mind that for many people, they've never been to court before, while others may be very comfortable in a courtroom. So our role is to, in particular, help folks that are less knowledgeable on the court system navigate the really complicated system. All right, so there are a lot of different reasons that somebody might be going to court. So in our work as advocates, the things that you see on the screen here are some of the more common types of cases that you might be helping a victim survivor through. Some advocates may focus strictly on one issue, like helping folks write orders of protection and harassment restraining orders, while other advocates may attend all different types of hearings. It will really depend on the agency that you work for and your role in that agency. However, it's still really helpful to have at least a basic understanding of the different types of cases, because a lot of the times the people that we're working with are navigating more than one legal issue at a time. And of course, just to make things complicated, each legal issue has different kinds of hearings. For example, a criminal case will have court dates for arraignment, omnibus hearings, possibly a trial, sentencing, things like that, while an eviction case may often just have an initial appearance, and that's about it. Your job as an advocate is to learn about what kind of court case the victim survivor is facing and have a good understanding of how that court plays out. So what's the timeline here? What's the next step in that hearing? Oftentimes the court system can feel really disempowering, and helping the victim survivor prepare with as much information as possible before attending can really help them at least feel slightly more comfortable. We can't promise any outcomes or tell them exactly what will happen in those hearings, but we can at least tell them what the strategy is for that hearing and what we're preparing for. To learn more, and I know we have said this and we'll continue to say it, but really do check out some of our past webinars on our YouTube channel. I also refer folks a lot to Law Help MN, where there's a lot of really basic information about the court process, and you can share that with those you work with as well. There are different law libraries and self-help centers that you can refer folks to. And the Minnesota Courts website also has a lot of information where you can learn some of that as well. And Jay is on it with the YouTube channel. Thank you. All right. So we're going to jump into a little bit about what court prep looks like. And there are so many things to be thinking about when you're helping folks get ready. So please throw some other ideas in the chat as well, because there is no way that I could possibly cover everything. So in terms of court prep, it will depend upon what type of court hearing you're going to, but we'll start with some of the basics. First and foremost, everybody wants to have an attorney when they go to court, and for good reason. Definitely know the resources for good referrals in your area, such as legal aid, pro bono, or sliding scale referrals that you or your agency have gathered. There's the Minnesota Unbundled Law Project and mnlawyerreferral.org. Like Maddie mentioned, you want to set people's expectations for what legal aid representation looks like and their capacity. But some of these resources can be good to know about and start building those relationships with. And of course, not to brag, but Standpoint is also a really good referral for folks too. You can help the attorneys here to talk things through, or you can always call us as an advocate and learn about that information as well. Keep in mind that if someone already has representation, we are not able to give second opinion or offer legal advice, but we're a great spot for folks that are unrepresented. So next, read through the documents, go back to that paperwork. So whatever these documents are will depend on the kind of hearing, of course, but that might mean reading through an eviction complaint to find out the reason for eviction, or maybe reading through a petition for divorce. This will help clue you in about what kind of prep needs to happen and how you'll approach the hearing. This brings me then to my next point, which is to submit any evidence and witness information before the hearing. I also suggest having printed copies available as well, just because it's easier for me to stay organized that way, but use whatever strategy makes sense for you. If you have like paper or printed documents, you can write notes on those documents. You can have sticky notes, highlighted portions, whatever it is that you need to have in the hearing. So that's why I like to have those printed copies. And to find out how to submit evidence, make sure that you're calling court administration. Be very, very kind to court clerks and to other admin folks, because they are the gateway to so much information at your courthouse, and they'll be really, really helpful to have a positive relationship with. For folks that don't speak English or have limited English proficiency, request an interpreter beforehand. Even if you feel like your conversations with the victim survivor are going well and you can understand each other, remember that it's really important to have an interpreter available in a court hearing, because there's a lot of new words sometimes for folks to understand, and it's just a really overwhelming space to be in. We want to make sure that the victim survivor is able to communicate their needs and communicate what they need to the judge, and that they understand what in the world is happening. Sometimes for folks that do speak English well, figuring out what's happening is already complicated enough. We don't need language to be an issue. And then finally, as you're working with a victim survivor, it's important to keep in mind what kind of hearing you're attending and why. I'm going to use housing as an example. I know everyone is totally shocked by that, but in an eviction hearing, for example, the landlord-tenant relationship has often deteriorated. The tenant may feel wronged or have had some bad interactions with the landlord. They're unhappy with the repairs that haven't been made, or whatever the situation might be. But at the end of the day, once you read the eviction complaint and know that the landlord has filed an eviction due to non-payment of rent, we have to make sure we're keeping our focus there while we're in court and in all of the paperwork that we're submitting. So while the backstory of what happened is really important and can really guide our advocacy work, we want to make sure that we're keeping an eye on the prize. So maybe have a list of things that you want to remember to say in court, or even a list of things that you don't want to talk about in court. Remember why you're there and what the point of that hearing is. If we think about criminal court, to use another example, there are so many different kinds of hearings, and all of them have a different purpose. So at an arraignment hearing, we know that the defendant is informed of the charges against them and their rights, may choose to enter a plea of guilty or not guilty, and that we might address bail and conditions of release. This is not the hearing that is going to dive into the evidence and really hear from the victim survivor about what happened. So really making sure that the victim survivor knows, why are we going to court today? So now that prep work is all done, we want to think through the logistics. So first, of course, is making sure that the victim survivor knows when the hearing is and is able to clear their calendar of all of their appointments, whether that's work, other meetings, things like that. We want to make sure that the calendar is cleared and everyone knows where to go and when. There are times when requesting a continuance may be appropriate, but for the most part, plan to attend that hearing as scheduled. If the victim survivor has children, sorting out childcare is really important. If your organization can help do that, fantastic. Otherwise, finding a reliable family or friend who is able to provide that childcare will be fantastic. And make sure to have a good conversation with whomever is providing childcare about the importance of being on time and making sure that everything is good to go there. We don't want to be stressed out in the morning trying to get over to court. While I often have pretty big feelings about dress codes being victim blaming, court hearings are definitely not the time to take a stand on that issue. So you want to dress in a way that lets the court know that you take the matter very seriously. You, the victim survivor, whoever is showing up in that space. Doesn't have to be fancy. I kind of describe it as business casual, though that does mean something different for everybody. So making sure that we're steering clear of jeans and sweatshirts and things like that. I often recommend not wearing a lot of jewelry that's going to make a lot of noise or kind of be like just bulky and things like that, but that's maybe a personal preference of my own. Like bracelets kind of clink around a lot. So that's the thing that I just personally don't do. Get to know what your court finds to be appropriate. We as advocates were having a conversation the other day about open-toed shoes and whether those are allowed or not. The Minnesota court website describes appropriate clothing options as conservative and reminds us that, quote, shorts, t-shirts, plunging necklines, and torn clothing are not appropriate. So if possible, help the victim survivor find something appropriate in their own closet, offer any clothing or clothing closet referrals that you might have, and help them figure out what's going to be comfortable. Not only appropriate for court, but comfortable, because there's nothing worse than feeling super uncomfortable in a courtroom and when your pants don't fit right or something like that. So find something that fits and feels good for them. Next, you'll want to discuss the arrival. So how is the victim survivor getting to court? Do they need bus tokens maybe? Do they need a computer to attend a virtual hearing? Helping folks make those logistical plans can be really helpful. So finding bus routes or figuring out where parking is. You know, even with parking, do they need quarters for a meter? Is there a parking ramp? What does that look like? Maybe you have the option to drive the victim survivor to court. Fantastic, love that. Just plan ahead, find a time to meet up, and make sure that you allow plenty of time. It may be you're meeting the victim survivor at the courthouse. You'll still want to plan for a meeting space, whether that's in the courtroom itself, or not the courtroom, but in the courthouse itself, or maybe across the street at a coffee shop so the two of you can walk in together, whatever makes the most sense. When you get to court, you can also find a separate room to meet in with the victim survivors so that you have a kind of a private space, the victim survivor can feel safe. And then know when you leave court, we're kind of jumping around a little bit, but when you leave court, you can also request an escort from security to get back to your vehicle safely. And I think that that can be really helpful for victim survivors, especially at order for protection hearings and things like that, where they're having to face someone that might not be safe for them. And finally, and I cannot stress this enough, plan for an earlier arrival time than you think. You'll need to park or take the bus or get the computer set up. Get to the courthouse, go through security, find out where you're supposed to be, check in. There's kind of a lot to do when you first arrive. I tend to be a little bit more of an anxious person, so I like to have a little bit more time to prep and kind of get my head settled and kind of in the game. But tailor that to the needs of the person that you're working with. Either way, still plan to be there early. It's just easiest in case something were to happen. All right, so next, we're going to talk a little bit about in-person hearings and what that looks like. So if and when possible, I do like to show a victim survivor what a courtroom looks like before a hearing. You could even use like a cartoony picture like this. Maybe this one's not the best example, but something that gives them an idea of what the courtroom is going to look like, even if you draw out a diagram. The next thing I like to talk about is who's going to be there. So thinking about some of the folks on the screen here, the judge, the deputy, the clerk, interpreters if you've requested them, victim witness advocate, who is going to be in that space, and kind of point out those key players on your diagram or your picture or whatever that might be. Who is going to be sitting where? Then you can talk a little bit about where you will be as an advocate. And, you know, in many order for protection and harassment restraining order hearings, that means you might be sitting directly next to the victim survivor. If you're attending a family court hearing or a housing hearing or something along those lines, you might be seated back in these chairs here. So have that conversation about what your role is in that hearing and where you'll be seated. And then reminding folks that as an advocate, we're different than attorneys. So we do not speak in court. We're oftentimes, some places will allow you to speak in court, but what you'll want to do is really talk to the victim survivor about your role as there as support. So you're not there to speak on their behalf. You're not the attorney. You're not doing those sorts of things. I know there are differences across the state and what that looks like. So again, finding out what your court does, what other advocates at your agency do, and what makes the most sense in your courtroom. Talk with the victim survivor about decorum. This is a very professional space, and that can sometimes feel incredibly cold or punitive for the victim survivor, especially when they're talking about some very personal and very traumatic events. There are plenty of basics that you can always talk with. Be respectful, use appropriate language, address the judge as your honor. Those sorts of things are really good. They're also much more difficult to do in reality. We know that the abuser or the opposing side may say some unbelievably painful things. And again, we're talking about some very private, traumatic things in a courtroom full of strangers. So it would be really, really natural for someone to have reaction. Remind the victim survivor not to argue or interrupt, and to speak directly to the judge when they're able to do so. Again, this can be super difficult and really hard. So just kind of prepping folks for that. And then you can also make a plan with the victim survivor to talk after court, to shout or cry or whatever it is that they need to do afterward. So doing a good debrief after the hearing can be super helpful. And then finally, the court's website specifically states, in case this is you'd like to know, you cannot chew gum, eat, read a newspaper, sleep, wear a hat, listen to earphones, carry a cell phone or pager unless it's turned off, and have a camera or camera phone or carry a weapon. So they listed those things out because those things definitely did happen at some point. So don't do those. And next, we'll talk a little bit about Zoom hearings. Again, if you have other pro tips on Zoom hearings, please toss those into the chat because there's lots of different tricks to learn with Zoom. But there are some special considerations to those Zoom hearings, though much of the prep work is going to be the same. So treat a Zoom hearing just as you would an in-person hearing in terms of the professionality. Dress appropriately, use appropriate language, all of those things. Definitely do not do anything that's not allowed in a courtroom. Seriously, just don't do it. In the beginning of the pandemic, we saw lots of very interesting things happening in court hearings across the state. So again, be professional. Probably the biggest conversation to have with a victim survivor is about technology. So do they have the correct Zoom link? Do they know how to use Zoom? Have they used it before? Really make sure that you're focusing on where's that mute button, because that's going to be really helpful for folks. Something that I like to do is remind folks that they can pin the judge so that they don't have to see any faces that they don't want to. If that doesn't work, you can also use Post-it notes and put those on the computer screen. So that, again, you don't have to look at any faces that you don't want to see during that hearing. You'll want to make sure that any distractions are eliminated. So if there are, children, you want to make sure again that there's childcare available for them. So there's no interrupting. Hopefully summer is coming soon. So make sure windows are closed. So any neighbors that are mowing the lawn or something like that during your hearing aren't distracting. Whatever you need to do to make sure that you can really solely focus on the court hearing at hand. So setting up your space in a way that protects confidentiality and is just easy to navigate. Again, there are plenty of other preparations that you can do for a Zoom hearing, but those are some of the basics. And then finally, the last slide for me, one of the hardest things about court is that there are so many unknowns. Doing some really good court prep with people helps alleviate some of those unknowns to tell them what to expect. And a part of that is having a really good conversation about time. A lot of the times when you're involved in any kind of court process, it feels like hurry up and wait mode all the time. Hurry up and turn in your paperwork, hurry up and get this taken care of, and then you're going to wait. Sometimes you're waiting for a hearing, sometimes you're waiting for a decision, whatever that might look like. That can be really stressful, especially when we know people are operating from a sense of trauma, from a space of trauma. Sometimes those hearings get rescheduled anyway. So you show up at the hearing and they get rescheduled. So that time management is really a hard conversation, but really important to do. Sometimes there are hearings that are simply set to schedule new hearing dates. And that can be really frustrating. Or maybe there are continuances. Those are all normal, but really frustrating to go through. So do what you can to validate that experience and just know, tell people you're sorry that they're going through that, all of those really good advocacy skills, and that it is unfortunately kind of a normal part of our justice system. The length of time from the first motion in a case to the final order will always depend with every kind of hearing. And unfortunately, that answer just sucks. So just let folks know that you'll be there to support them along the way and help them navigate that. Another reminder I find helpful is that sometimes things occur off the record. Maybe someone accepts a plea deal or there's a settlement agreement outside of a court hearing. So you might not see every single step occurring in the courtroom. And sometimes that's just surprising. So just letting people know that. No matter where you are at in the process, it's always important to help the victim survivor make sure that they're very clear about what the next steps are before they leave that hearing. So will there be another court hearing? Do they need to prepare a written legal argument and talk to an attorney? Maybe there's a case plan and they need to seek treatment or other kinds of services to move along successfully in that case plan. Maybe they need to file an affidavit of compliance. And yes, that is another housing reference. Make sure it's clear to the victim survivor and to yourself what comes next and what kind of follow-up should happen. Even if it's what we think of as the last hearing in a court case, sometimes there is still some follow-up work to be done, so be very clear about that. Finally, as a big proponent of self-care, like Elli was talking about earlier, we want to, and building resiliency, we want to talk about emotional well-being. Talk with the victim survivor about what kind of care they may want after a hearing, especially if that hearing doesn't go the way that they wanted it to. This is not the self-care webinar of your dreams by any means, but Elli mentioned a few that we do have on our YouTube channel. So I know a lot of that was super, super fast. I know we've got lots of information to talk through, and I'm going to turn it over to Anna Maria to finish us out for the day.
Thank you, Raelene. And I feel like the anchor leg in the relay race. Normally it's the fastest, so I'll try to slow down. I'm going to talk about legal advocacy with special populations. My name is Anna Maria, and I'm the Advocacy Support Program Manager here at Standpoint. We need to keep in mind that because of the discrimination and oppression these communities have experienced, they will probably come to us asking for help when they have reached their limit of tolerance of the abuse, and they are in fear of being severely harmed. Next slide, please. The common barriers for these communities. Some of the barriers these populations have in common, one of them is the fear of law enforcement. They are less likely to call the police, report the abuse, or seek support. And the fear is based in numerous factors like previous experience with law enforcement that didn't go that well, higher vulnerability to police brutality and misconduct, fear of deportation on immigrant communities, fear of double arrest in LGBTQ+ communities, for example. They have also experienced the feelings of not being seen, not being heard, distrust of DV and sexual assault agencies, because there is some skepticism and distrust that domestic violence shelters and intervention services are not culturally or linguistically competent. Isolation. These communities that have been marginalized, they have experienced exclusion, and some of them lack the support from family and friends. And abusers have that extra weapon to gain power and control. The rate of interpersonal violence is higher in this community. The economic inequalities, that higher rates of poverty, less job opportunities, higher rates of homelessness, and there is lack of cultural specific organizations to serve them. Next slide, please. Now let's talk about legal advocacy with immigrant survivors. As legal advocates, we need to build trust, explain our services, make sure they understand confidentiality, so our immigrant survivors feel comfortable talking about private and revealing information. They need a safe place to talk about anything they like without fear of that information leaving the room. Do we need to bring an interpreter? Some of them don't know that organizations have to have a language access plan, and advocates need to be trained on how to use it. Don't use children or family members as interpreters for legal issues. In rural areas, like where I live, where immigrant communities are smaller and tight-knit, Make sure the interpreter is not someone known by the survivor that you're working with, even with certified and trained interpreters. There have been cases where the interpreter have told the abuser everything they heard when the advocate and the client were meeting, what is completely out of their, irresponsible from their part, but it has happened. Remember about the Title VI of the Civil Rights Act? It protects people from discrimination based on race, color, and national origin in programs or activities that receive federal funds. If our organization receives VAWA funding, language access should be provided to our LEP clients. When we talk about the safety of immigrant survivors, we need to ask about the support system, their legal status, who is financially responsible for the family, who has a valid driver license. Is it safe for her to or for him to do a police report? What about an order for protection? Does the client knows that even if they're undocumented, they have legal rights in this country? All people in the United States, regardless of immigration or citizen status, are guaranteed basic protection under both civil and criminal law. This includes filing order for protections, divorce, child custody, and sometimes our immigrants are not aware of their rights. The fact that undocumented immigrants don't qualify for county assistance for themselves, for example, they might believe that they don't qualify to receive services from domestic or sexual assault programs, or they can go to shelters for safety. Also make sure they know that the services that we provide are free of charge. As legal advocates, it's important to know their legal status in order to see if there's any relief that they could apply for. But let's remember that this is not the first question that we should ask. They have to trust us before we start talking about immigration status. Does the victim knows if the abuser is the sponsor? Is she a citizen? Is the person a lawful permanent resident? Is there an open case? Does the victim knows the alien number? That will be information that is very important if we're going to talk to an immigration attorney. Is the survivor undocumented? Always get advice from an immigration attorney when working with victims of a crime that are immigrants. And remember, the abuser used the immigration status as the extra weapon of power and control. If we're going to do a safety plan, it's needed that we need to keep in mind that the abuser will get their hands on green cards, work permits, passports, etc. So their partner will have to think it twice if they want to leave. Have the client make copies of all the important documents they have, including birth certificates of the children, social security cards, marriage certificates. Those are very important. Next slide, please. Immigration relief options. It's good to know that there are some different relief options for immigrant survivors that are here in the United States and they're victim of a crime. We need to talk to immigration attorney as soon as possible to see if any of these relief options are available for the client that you're working with. The VAWA self-petition, the U visa, T visa, removal of conditions with abuser waiver, SIJS is a special immigrant juvenile status for youth that are undocumented in the country. Others are asylum or TPS, that is temporary protector status. And those are the asylum and the TPS are for some countries that can apply. So check the list of the country of the client that you're working with to see if they can apply for any of this. Next one, please. Now let's talk about legal advocacy with LGBTQ+ survivors. We know that the LGBTQ+ community experience violence at a much higher rate than the heterosexual community. More than 1 in 2 adults, transgender individuals experience some form of intimate partner violence, particularly trans people of color. The higher rate of dual arrest in LGBTQ+ community when they call law enforcement is high in comparison to reported incidents by opposite sex couples. And this is one of the reasons that much of the interpersonal violence in the LGBTQ+ community goes unreported. because it could result in loss of employment, financial hardship, loss of housing, and loss of some benefits like going to a shelter for safety, because now they're being seen as offenders in the criminal justice system. They could also lose custody of their children. Other reason that is sometimes, other things that happen is sometimes there is no arrest because law enforcement can determine who is the aggressor and who is the victim, leaving the victim vulnerable to more abuse. There is also the fear of outing, revealing their gender identity either on a police report or by the abuser before they are ready to tell their story. Fear of rejection from family and friends. All this becomes very real when we're living in a heterosexual focused climate where homophobia, biphobia, and transphobia is present in all systems, including the legal system. LGBTQ plus victims often don't seek services from advocacy programs out of fear of judgment, invalidation, discrimination, or further victimization. As legal advocates, we need to know what services we have to offer to LGBTQ plus clients in our programs, how to keep them safe, especially working with trans women looking for shelter. It's important to know how the judges in our counties respond to issues like filing OFPs, custody battles, parenting time, and other legal actions when they are coming from a victim survivor that belongs to this community. When was the last time your organization offered a training to provide the knowledge and skills necessary to sensitively and effectively respond to LGBTQ plus victim survivors coming to us for safety? Let's make sure we are using gender inclusive language like partner, parent, child, spouse. Are we using the correct pronouns for trans and non-binary clients? It is a way to let them know that we see them, we affirm them, we accept them, and they can trust us. Doing safety planning is needed. There's a lot of things that we need to add to the long list that we already have. Hormones prescriptions, wigs, binders, shaving tools, breast or other feminizing prosthetics. Abusers are destroying or hiding the prescriptions or the hormones they are using for therapy, for example. Also, let's building a network with cultural specific, identity specific orgs is very helpful. Next slide, please. Let's jump to talking about legal advocacy with survivors from tribal communities. In Minnesota, we have 11 federally recognized tribes, 7 Ojibwe on the north side of the state, and 3 Sioux on the south. Each tribe is a separate sovereign nation with its own government, their own court system, and some of them have their own law enforcement. More than 45 Native women and men have experienced a form of violence in their lifetime, and Native women have experienced significantly higher levels of sexual violence. Next, please. In Native women, interracial violence is more prevalent than intraracial violence. Until recently, federally recognized tribes did not have the authority to criminally prosecute non-Indian perpetrators, even for crimes committed on tribal lands. PL 280 or Public Law 280 was a transfer of legal authority jurisdiction from the federal government to state governments, which significantly changed the division of legal authority among tribal, federal, and state governments. Prior to PL 280, criminal jurisdictions was shared between federal and tribal governments, with little interference from state. Non-PL 280, it's called a jurisdictional maze because it has to take in consideration the location of the crime, the race of the victim, and the perpetrator, ties to the tribe. Is the defendant a non-native married to a native? It becomes very confusing in determining jurisdictional authority. Is it a tribe? Is it the federal government? Is it the state? And sometimes they overlap. And when this happens, often no authority acts to process the case, leaving victims without legal protection and offenders not paying for the crime. It happens frequently with non-native offenders. In Minnesota, Red Lake and Bois Forte are the only two tribes that do not have PL 280 enacted. It's important to know that a lot of tribes have advocacy services in the reservation. Some have shelters, either general or domestic violence specific. Some tribes have their own legal aid offices and their own attorneys. And attorneys need to be licensed to practice law within the tribe. They are tribal urban offices, especially in Hennepin County, and it's good to take the time to do our research and have a list handy for advocacy support purposes. Let's talk about ICWA, the Indian Child Welfare Act. It was established in order to protect Native children. Having ICWA in place, tribal nations can be involved in the termination and placement of Native children in child protection cases. If the child parent is Native, ICWA applies. And CPS, Child Protection Services, must notify the tribe if a Native child is at risk of being removed from the home. What to keep in mind when working with Native clients is the victim survivor register with the tribe. Can they get registered with the tribe? Where did the violence occur? Is the victims able to use any of their cultural specific resources available for the tribe they belong to, like legal aid, like shelter, like attorneys? Is CPS involved? Remember ICWA. If they need an attorney, remember that the attorney have to be licensed to practice law with the tribe. It is important to know also that tribal OFPs is an OFP issued by a tribal nation court, but it's good and is enforceable on and off the reservation. Make sure your victim survivor has a copy of the tribal order with her. At Standpoint has a webinar about tribal jurisdiction in Minnesota, and you can check it out in our website or on the YouTube. Next, please. Now let's talk about legal advocacy and people with disabilities. Disability covers a wide range of identities and communities, and 70% of people with disabilities experience some form of abuse. They are 3 times more likely to be sexually assaulted. Children with disabilities are disproportionately affected by various types of violence, and the rates of physical and sexual violence are almost doubled. The likelihood of violence is high, and the acts of violence themselves are also more frequent and severe. Now, the thing is 70 to 80% of the cases are not reported. People with disabilities are often isolated, and most of the time they're heavily dependent. In many cases, the perpetrators of violence are their caregivers, either at home or in institutional settings. And females with disabilities and seniors often find themselves trapped by violent partners or family members because they're financially and socially dependent on them for survival. Sometimes even a court appointment guardian is their abuser. Abusers use the disability to take advantage and to maintain power, and the abuse often takes in non-traditional forms like refusing to feed them, denying access to a phone, over-medicating or withholding medications, stealing or withholding finances. They can withhold their Social Security disability check, for example. Harming or threatening to harm their service animal, threats of abandonment, destroying or denying access to mobility devices like wheelchair, walkers. For court hearings, we need to help them request to have their hearing via Zoom because it's going to be really hard for them to go to court. As legal advocates, be open to different ways of communication with them using drawings or writing, for example. We need to use language that is to describe things that the survivor will be familiar with. Sometimes abuser is not familiar, so let's use the name of the person instead of the word abuser. We need to be mindful at the pace that we speak. We need to know if our shelter that work with us has a room accessible to a victim survivor with disabilities. Does the organization have the TTY, TTD device? Have we been trained on how to use it? Do we have a list of American Sign Language interpreters that we can call? We need to ensure that the safety planning measures include considerations for disability, service animals, and equipment, or other kinds of technology that they can use for help to stay safe. Medical needs have to be put on our safety planning. And develop a referral list of organizations that work specifically with people with disabilities. The Minnesota Disability Law Center provides free civil legal assistance to individuals with disabilities statewide, so it's good to know. Next slide, please. Let's always remember when working with any victim from one of these populations that we need to build trust. We need to explain our services. We need to be survivor-centered and trauma-informed. We empower, we encourage, we reassure, we listen, we enhance safety. We ensure that the victim's rights are protected. We provide a voice when needed. We let them express their needs and we respect their choices. Survivors need to be believed always. They need to feel supported and to know they are not alone. Broad view of safety, because safety looks different to each one of our clients. Be trustworthy, transparent. We need to recognize and be aware of the cultural and historical trauma and the kind of oppression these communities have suffered. Safety plan accordingly, make effective referrals, and we need to challenge ourselves about our own biases and prejudices. Next, please. Here are some resources that are very helpful, and this is for everybody that we work with. One is Law Help Minnesota. Is very helpful when we're looking for legal information or attorneys. A lot of fact sheets about legal topics, and you also find court forms. Lots of legal information about family, immigration, housing, abuse and crime victims, disability. If you have a manager, ask your manager if your program uses LOON, L-O-O-N. Is not available to the public, but it's for legal services staff, and you'll find great resources by county. Minnesota Revisor, you're able to find Minnesota statutes, Minnesota laws, Minnesota rules. If you work with the search by keyword, for example, if you put domestic violence, you're gonna find a lot of the language of the statute. Minnesota Courts Online, they're helpful to find access to court records, to look out cases. And then we have the OJP, Minnesota Programs and Services. They have information about services and resources for victims of crime in Minnesota. Make sure that it's updated. Sometimes some programs already they close or not available anymore, but it's a great list. And then I have some resources that are specific for some of these communities. For example, Out From Minnesota, they're really good. They work with LGBTQ+ clients. The Minnesota Elder Justice Center provides services for older and vulnerable adults. The Minnesota Indian Women Resource Centers, they have a lot of information for Native clients that we work with. The Youth Service Network, they help out youth clients to find shelters and services. And please feel free to call us if you have any questions. We're always available through emails or through our action line. And that's all I need to say about special educations. And thank you very much.
All right, so just to wrap things up a little bit, thank you all so much for coming and hanging out with us this afternoon. I know it's a lot of information. We know that advocates wear so many hats in our roles as legal advocate, as someone who is providing some crisis intervention. Know what that role is within your organization. Like Maddie said, a lot of the work that we do is about building and maintaining relationships. So make that phone call, build those connections with other people outside of your agency and within your agency as well. know your agency's policies on confidentiality and understand why that's important, and being able to explain that to the victim survivors that you're working with. Maintain healthy boundaries or learn about where your boundaries are. Elli talked a lot about that and why it makes us healthy advocates and that we can do the work for a long period of time. And then really know the difference between legal advocacy and legal advice. And then learn about your court. What are the expectations there? What does it look like? Who shows up? What does that all mean in your area, so that you can really be a good support for those you work with. And finally, seek an understanding of barriers faced by underserved populations. That's absolutely a part of the work that we do as advocates, so that we can serve anyone that comes to our door. So it's a lot that we talked about today. Legal advocacy is no joke. So we've got lots of things on our plate and lots of learning to do. But if you have any questions, like Anna Maria said, we are always available, and we are here, so is my cat, to provide any kind of support that you might need. So feel free to reach out to Standpoint at any time. And if anyone has any questions here, we're definitely happy to answer them. Otherwise, we'll wish you a wonderful rest of the afternoon.
I don't see any that have come in. Looks
Perfect.
like just some folks saying thanks and my cat meowing here. So if there are no other further questions, then I will end the webinar.
All right, thanks everyone.
Oh, someone's looking for the info on Loon. Do we perhaps have a link for that I can share in the chat? Or is that something they need to talk to their supervisor about, or?
That is something they need to talk to their supervisor to see if they're, because you have to have a password and you have to have a way to sign in Loan. So they should ask their manager or somebody in their program.
Awesome. Thanks, y'all. Thank you for joining us tonight. And when the recording is available, it'll be added to our YouTube page and then also sent out to the Legal Advocates listserv. So thank you to all of our presenters today. And thanks for joining us. Have a good day.